here since 1951. This is The Legend. 105.3, 95.3, WDXE.
Hey, that hour snuck up on us, Stan.
It did.
It is Stan Pierchoski and Bulletproof Estate Planning right here on WDXE.
Good morning.
Had that moment of silence there for just a moment.
Happens to me all the time.
Had to do the switching around of things.
It's not only a moment of silence, it's usually a moment of inaction. It's like, it happens to me all the time, I know.
Well, it's been a whole week, hasn't it?
has.
Actually, it's been 2 weeks, because
No, you were here.
I was here last Friday.
It was a couple weeks ago.
Yeah, Lonnie was out.
Yeah.
Lonnie did the other week.
LB was in there. Yeah.
LB was in here one Friday for us, but
or as you lovingly refer to him as Box.
yeah, Mr. Box, Mr. Box.
How do you spell Lonnie's last name?
B-O-X.
I was going to say, I thought so I figured, but sometimes when you use it for a name, it usually is not quite the same.
Yep.
It's
That's
like one of my, well, anyway, yeah, that's, but next week, we might as well talk about next week.
We might as well.
This is Bulletproof Estate Planning. We do the show every Friday from 8 to 9 o'clock. And I can't go by your clock because it hasn't been adjusted for daylight savings.
yeah. It hadn't been, has it?
And but from 8 to 9 every Friday morning. And next week, though, of course, Thursday's Thanksgiving.
Yes.
And Friday's the day after. So next Friday, I think they'll probably just, if they do anything at all, they'll probably play a show earlier that we did earlier that we recorded.
Right.
Yeah,
right.
that's fine. Just don't pick the one we do today, so there's two in a row.
We'll try to get one of the encore presentations.
Pick one from a year ago and see what we're talking about then.
Yeah.
But yeah, that's the holidays are here, so we want to, and I notice all the Christmas decorations are out. And
Oh yeah, they're already out.
they I was watching something on TV where they had some people and they were asking them, should it be okay to put up Christmas decorations before Thanksgiving?
Yeah.
I'm personally of the opinion that I don't want Thanksgiving to get like absorbed into Christmas. I like to do. The decorations, I guess, are okay. But,
Yeah.
I don't want to forget about Thanksgiving.
Absolutely
I think
not.
It's a tremendous amount of a Christian effect to be thankful. For,
Yeah.
I mean, it's easier. There's so much more to it than just say be thankful.
Absolutely.
If you sit, quiet your mind and reflect, and you will come up. Even I don't care where you are in your life, you'll come up with a lot of things that you're really thankful about.
That's right.
And sometimes a good way. You know when it really comes up to me sometimes. I deal with a lot of folks, and I feel a lot more. Some elderly folks. When people when their life is really difficult.
Yeah.
And sometimes you look at it and you say, I'm embarrassed that I'm complaining about.
Right.
My shoulder's sore, or
Right.
my kid's giving me trouble, or I gotta go home and clean the garage. It's like things could be so much worse. So just things like that. And then if you're going to compare yourself to folks, and it's a good opportunity to be helpful too.
Yep.
So, I'm not here to preach. I'm just saying, don't not celebrate Thanksgiving because it's firmly rooted in our culture, and it's a good time. It shouldn't just be that day either. Just like Christmas, you don't think about these things just one day a year.
The history of Thanksgiving in our country is fascinating.
It is. It certainly is. So
It really is.
I know. When I do, well, it's not your sister station anymore, but I'm on the radio on Thursday mornings in
Yes.
Pulaski.
Yeah.
And several years ago, we started doing this. I would always do it. They call it Stan's Oldie of the Week. I would pick usually something from the '60s, maybe early '70s, back when I grew up. And I was trying to come up with a song that was giving thanks. In the rock and roll era, it was kind of hard to find one.
Yeah.
So the one I came up with was by the Beatles, which is my favorite group, and it was called "In My Life." Okay.
Yeah.
And in my life, I remember there was John and Paul, who wrote the song, were sitting down and they were reflecting back on a lot of things in their childhood and stuff, and they were the conversations like all these childhood memories of ours and all these things that we did as children just shaped us into what we are today and stuff.
Yeah.
And that's what that song was about. So
Yeah.
that was thankful.
It's a good song.
I was thankful.
Good song.
Anyway.
Yeah.
All right, so we are Bulletproof Estate Planning, and we talk about estate planning on this show, and it's an interactive show, so you can call in, and the telephone number is 931-766-9393, 931-766-9393. And my seminar in Franklin is tomorrow, November the 22nd. We do it at 10 o'clock. If you want to come to that, it's not that far of a drive, because I don't know when the next one's going to be in Lawrenceburg, because we do them about every other month, and then so the next one's going to be in January, and probably the second half of January, get past the holidays. But I go to I do about 4 or 5 different counties, and so it might be a while until I'm back in Lawrenceburg. Now we usually do Giles and Lawrence a little more often, just because that's where we are, but I don't know when it's going to be. But if you want to come to the seminar, it's up in Franklin, and it's at the Williamson County Public Library. The physical address of that is 1314 Columbia Avenue in Franklin. It's not a bad drive up there, 40 minutes, maybe 45, I don't know. Saturday morning, wouldn't be much traffic. We could do that 10 o'clock in the morning. The name of the seminar is called Wills, Trust, and the Nursing Home. And basically, what we do there is we go through a quick review of will versus trust in general, and then we move right into the asset protection portion of it. And, I used to call the seminar "How Not to Go Broke in the Nursing Home," but I thought maybe
Which is important.
Thought maybe that title was a little too aggressive. So
Yeah.
now we talk. But and that's what it's about. So if you're concerned
Sure.
about that, but we also talk a little bit about the revocable living trust. Because really, there's only a handful of trusts that we actually do
Sure.
in my practice. We do the revocable living trust and the asset protection trust, which are similar in a lot of ways, but they do accomplish two separate goals. We do special needs trusts. We do some other, just a handful of other kind of trusts, but for the most part, there's only a few that we do.
Sure.
And I mean, there's a lot of other kind of trusts out there. They're fancy ones. There are a lot of IRS type tax benefit trusts. I don't do any of that. It's not my forte. I have plenty of business doing what we do. So, but if you're interested in that and you want to hear about them, you need to come to the seminar or give me a holler. We have a recorded version of the seminar, which I desperately have to update. I'm thinking the holidays are going to try to do that.
Yeah.
But if you trust is an alternative way to distribute property after death.
Sure.
Most people think a will is all they can do. It's not. There are other options, and they are better options, in my opinion. Of course, I'm biased, but once you hear how they work, you probably agree with me. So, come on to the seminar at this late date. Just pop in. If you get a chance to call us and let us know how many are coming, that's great because we have up there we have tables and chairs we can set out. We'd like to set out enough for people. So that's why we need a head count. Plus the girls will have some very light refreshments, and so yeah, you can. It's not too late. Come on. Inevitably we have a lot of walk-ins, and we always have a handful that plan to be there, and that something happens at the last minute, you can't come. So
yeah,
we got a pretty good crowd. So we'll see how it works out. But by all means, drive up there and attend the seminar. Hear what we have to say. I mean, there's no obligation. I had somebody call me once. It's happened more than once, but I can remember this one time. Guy calls me. And he says, I was thinking about going to your seminar. And I said, great, He said, do you need anything from me? I said, just give me your name, your phone number, and how many are coming. He said, well, probably just me and my wife. And he said, what do you need the phone number for? I said, well, the girls like to call the day before and just remind people, hey, the seminar's tomorrow. Yeah. Something like that. He said, okay. So he gave me the phone number. And he was kind of reluctant, I felt like he was worried I was fishing for information. Yeah. And I said, no, that's all we need. And he said, is it, is there some kind of high pressure sales thing or something? If you're ever going to one of these things, you get something in the mail and it says free steak dinner at this restaurant.
I see those every once in a while.
And then when you go to it, you get the dinner, but you get this a big time sales pitch too for whatever it's
for whatever.
So he's kind of beating around the bush on that question. I said no, no big deal. I said, and so about it was like a day or two later, but before the seminar. Another gal called me. She started asking questions, and finally she said, "Look, I'm calling for my boss. He's already signed up for this thing, but he wanted me to call because he said he wants to know what's the catch." And I said, "There is no catch. I said, "You can come." And she says, "Well, I don't know. You're going to make him sign something when he gets here?" I said, "No. I mean, you come in, you sit down, listen to me. If you don't like what I say, get up and walk out. Just be quiet about it if you don't mind." But it's not like I lock the door and say, sign here, we're not going to let you out. And she said, well, he just said that no lawyer is going to give 2 hours of his time for nothing like that. And I said, well, maybe all of them won't, but one. Yeah. And I remember I ever said this. I tell your boss that not only do I give him 2 hours of my time for nothing, I'll also feed him. Yeah. Say, we'll have refreshments there for him. So say, but don't make, tell him not to be uncomfortable. If he doesn't feel comfortable coming because of that, don't. But I'm telling you, just show up. Now, I can't remember if I ever talked to him or went forward because I can't remember who the person was. But anyway, it's not that kind of thing. I mean, it's a presentation. I will tell you what it is, though. It is from the minute I start to the minute I stop. It is nonstop information. okay? And it needs to be, but don't let that scare you away. Because a lot of the stuff you hear, you will not have heard before.
Sure.
Or if you listen to me on this radio station, you will probably have been exposed to it to some extent. And
Yes.
don't, just because, what makes it sound complicated sometimes is because it's brand new. When it's like, a while back, I like to study scriptures. You and me talk about it all
Yeah.
sometimes. And
Yeah.
A while back, I wanted to be able to understand scriptures in the original manuscripts, which is written in 3 different languages.
Yeah.
It's written in Hebrew, Greek, and Chaldee. Parts of
Yeah.
the Book of David are in Chaldee. Well, I decided I wanted a working knowledge of Hebrew. Okay, so I got some Hebrew study books. When you open them up, I looked at it and said, "Oh my gosh, this is not even possible." To understand this, and that's what something brand new looks like.
Yeah.
But if you say, okay, well, let me start with the beginning and see what we can learn.
Right.
And I kind of taught myself. I can't read it, and I can't speak it, but I have enough of a working knowledge that when I can compare the scriptures with the original manuscripts, and that's what I was trying to do.
Yeah.
Because there's definitely translation. I don't want to say errors, but there's loss, translation loss.
Yeah.
And that's what the italics is in your King James book. The words in italics those are the words that in the original King James of 1611, they had a 4-page disclaimer kind of that said, hey, some of the stuff in here didn't translate exactly right, so we had to put in filler to make it into English.
Sure.
And those are when you're reading a passage, some of it's in italics.
Yes.
And that's what that is. Those are the ones that don't quite jive from one language to the other. And there's several places where that meaning's lost.
Yeah.
Or confused, at least. Not,
Yeah.
I wouldn't say lost, but confused. But anyway, my whole concept is when you take something on that's brand new, it just feels like whoosh, over your head.
Right.
This is a lot. And that's how some people feel sometimes at the seminar, but don't just let it, because usually when people come and talk to me and we go through it kind of the second time, then they're starting to get a real grasp of it. So, and that's why I do the radio show. So if you're listening to me and we talk about these topics, it won't be the first time you've heard it. It'll kind of it'll
Right.
sink in. It's not rocket science. It's just brand new.
Yeah.
Because so many times I've heard people say, I want to do a will. And I say, well, great, we do wills, but would you like to hear about options? And they would say, I didn't know there was. I thought oil was all you could do.
Right.
And there's a situation where they don't even know what the options are.
Right.
Now, don't take that the way it sounds. I'm not being judgmental or pointing the finger. If you don't know, you don't know. So
Well,
ask. And then once I tell you what the options are, when we talk about it, and
Yeah.
maybe Google it or something, you'll learn that there are options.
Yeah. For so many years, though, we've been preached to by almost everybody in every source that, get a will, make sure you have a will. And that you don't hear about the trust.
Well, that's true. Or you hear about them that other people do, and
Yeah.
the other people have different finances.
Sure.
Many times people will say, my estate's not big enough for a trust.
Yeah.
The translation there is, that's only for rich people.
Yeah. Yeah.
I really object to that because, when you have rich people, they got a lot of money, and if people contest the thing and they use a lot of money contesting it, there's still tons of money left over to divide up, right?
Yeah.
If you have a very modest estate where you say I haven't got much, well then all the more importance that it goes where it needs to go and not be consumed in any
Sure.
kind of a contest,
Sure.
right? So it makes it more important. I think you're better off with a trust with a small estate, and they work the same. The trust does the same thing for a big estate that it does for a little.
Right, right.
It's not. It doesn't it's not like it favors you if you have a lot of money versus not so much.
You keep going, I gotta fix an arrow.
Sure. Am I still broadcasting?
Oh, yeah. Yeah, you're
As long
on.
as I'm not talking to the ether.
No, you're on. I just gotta change the title, but you're good.
Well, we don't want Miss Charlotte coming in and yell
Yeah,
at you.
she will fuss at us.
She'll yell at you. No, she runs a good ship. But these options are out there if you want to learn about them. And most folks that are thinking about doing a will or some kind of estate planning, that when I tell you that there are options, then they're interested in hearing what they are.
Yeah. Well,
Which is why when I get to the seminar,
Yeah.
when I'm talking, you can practically hear a pin drop the whole time because people are hearing things they haven't heard, and when they hear what the things they haven't heard do, then we really got their attention because they are good options. It's what got me into this business in the first place.
All right.
I'm sorry, you were going to say something?
No, I was gonna turn the phone up too, so we can hear it when it rings.
Okay.
There we go. That's just me turning it up. So there we
Okay.
go.
I was going to say, wow, that's a coincidence.
Yeah, very, very good. Very good. I think I've got everything straightened out.
Yeah. So, it's there you go.
Yeah, very good. Well, it's one of our regulars.
I was at a breaking point anyway.
Hey, good morning. You're on with us. Peggy, you're on with us. Oh, she can't hear me.
Now,
for
that
some reason.
question I can answer.
I don't know why she can't hear me, but anyway, Try again, Peggy. I don't know what happened. We couldn't hear you. So there we go. All right. And the mics are on. Everything's on. We're good.
So anyway, we have the seminar coming up. If you want to come, I get a lot of good reviews on my seminar. Come on, and,
Yeah.
you know.
Yeah. Those seminars are good. And you've now maybe let's try this one more time. Hey, good morning. You're on WDXE with us.
Can you hear?
Yes.
Okay, last week I called and asked about that contesting. You know, if you put this thing in a will and you say, if anyone contests this, they're to receive nothing. He covered both the will and the trust, but I had allergies real bad. And my question is, would it be worded differently in a will than it would be in a trust to prevent problems? I looked up on the internet different reasons that people might be able to contest and still get it, but I wondered if the wording would be different in those things. And you don't have to answer today, you just might cover it later. It was something I thought about.
All righty. Very good. Thank you.
I think we did cover it, but I'll do it again.
Okay.
Because it's probably worth covering. You know, it's in Latin it's called an interim clause. It means no contest. And you can put it in, any instrument really, but we're talking about wills and trusts. But you can put the language can be very similar, okay? And you can say if somebody let me be careful about what we're challenging, because there's some things you can challenge that don't trigger the no contest clause, okay? So basically what it says is if you challenge what you're getting, so like, if you got a will or a trust and you get 25%, because you're one of 4 kids or something, and you're thinking, I think I deserve more than 25% because I'm the one that takes care of them. I mow the grass and I make sure they get the groceries done, and the other 3 don't do near as much. So I think I should get more than 25%. And so you want to challenge what you're getting, okay?
Okay.
That is what triggers the no contest clause. And so if you challenge what you want, what you're trying to get out of it, then the language says if you challenge this, you pretty much take as if you are predeceased, which is nothing. Okay, you're removed from the hierarchy of the distribution. Now, that's what the no contest clause, and that's when it's enforceable. But suppose it's something like this. Suppose you have, the executor of the will or the trustee of the trust, who's the person in charge, right? Suppose the person in charge says, you know what, Stan gets 25% here. Mom and Dad are leaving Stan 25%. But you know what? He hadn't even sent them a Christmas card or even called them in 10 years. I just don't think he deserves that 25%. I'm only going to give him 10. Okay? Now, I can challenge that and not trigger the interim clause because I'm not complaining about what I get. I'm complaining that they're breaching a fiduciary duty and not giving me what I'm supposed to get. I'm not challenging what I'm receiving. I'm saying I'm happy with the 25%, but I'm getting screwed out of it because the trustee is breaching their fiduciary duty. Let's analyze that a little bit. Here's what's happening. The trustors wrote the trust and wrote in there that I get 25%. Because that's what they wanted. And the legislature's in trust. Now, wills, you can put them in a will, but they're not very enforceable. I mean, they don't have as much strength in a will. In a trust, they're 100% enforceable because the legislature has said the trustor, which is the writer of the trust, the trustor's intent is paramount. And absent some compelling evidence, will not disturb that, okay? So if they put it in the trust, and I get 25%, that's what they wanted to have happen. Now, at their death, they're not here to argue, so that we have to go by what their intent was in the instrument. And if somebody says, I don't think he deserves 25%, I'm only going to give him 10 because, he's a dirtbag and doesn't do this, or he never takes a shower, or whatever the reason is. Now, that trustee is substituting their judgment for the trustors, which is what cannot happen. That is, by definition, a breach of the fiduciary duty because you have to do what the trust says. You have no creative thought as a trustee. You can't change it. Nobody, even during life, nobody can change the trust but the maker of the trust.
Yeah.
The trustee has no authority to change anything. Their job is just to handle the property that's in it. So, this breach of fiduciary duty, I'm going to give you an example. I had a client, I probably used this before, but it's a good example. Had a client was sitting at my conference table, right across the table from me, and he said, those are the words he said. And it was a pretty good sized estate, but he said, my sister up in Columbia, Mom left her $200,000. He said, she is exactly what he said. She never sent him a Christmas card, not even called him in 10 years. I don't think she deserves that. And I remember my words to him. I said, well, I'll tell you what, here's my advice. Bite your lip, hate every second of it, but write the check, because if you don't, she will sue and she will be successful. And don't ask me to represent you because I can't win that one. I mean, you have to do what the trust says. It's
Yeah.
straightforward. And because if you decide to change it, you are substituting your judgment for them. And when you think about it, that's the whole idea of the powers of the trustee or the executor, is so they just do what the will says to do without any thought towards whether it's good, bad, equitable, not equitable. Their opinion of it has nothing, never enters the equation. If the trust says you get 25%, that's what you distribute, whether you like it or not. That's why sometimes independent trustees are better.
Yeah.
But, so the question was, about challenging, the wording can be different, but doesn't need to be. The wording just needs to be, if you challenge this, you will take as if you predeceased. But you could put your own wording in and say, if you challenge this, then you only get half. It doesn't mean you automatically get nothing.
Right.
But if you're going to challenge it, that's usually what the consequence is because the trustor who's now deceased is saying, look, take what I give you and be happy.
Have you ever seen that happen where someone challenges and then they're just completely cut out?
I have seen it get really close to that.
Really?
There was a trust one time where they're to be cut out. They challenged it. Their attorney kind of eventually told them it's not a good thing to do. They actually filed the suit, but they withdrew it.
Uh-huh.
And now the question became, was that a challenge?
Yeah.
And strict reading of the language might say so, but also there was enough ambiguity in the language that would say the challenge would have to be where you actually got to the controversy.
Wow.
You filed it, but it never got into negotiations or never got into. I think, as I remember right, the petition was filed and then they hired the attorney, and then. Now, it wasn't one of mine either, but I was involved with it collaterally. But yeah, so but I read court cases that deal with it, and that happens.
Oh yeah. When you were talking there, that just made me think. It seems to me that is the power of that trust, is what you're creating for yourself and your heirs, is to see that what you had envisioned happened or happening will happen, and it can't be really knocked out of the park or changed or whatever. So.
Well, again, let's think about it. If it's your stuff and you're writing a trust, it's your stuff, right?
Yeah.
And you feel like I can leave it to whoever I want,
Right?
In whatever portions I want,
Right?
And that's what I want done.
Right.
So at your death, that you want somebody to be able to change it, just on whatever they think is substitute their judgment for you, and think, well, Jeff didn't really understand what fair was. This is what's really fair, and I'm going to change it to that. Of course not. Yeah. That's what the whole intent is. That's why the language of the legislature is the trustor's intent is paramount.
Yeah.
That's pretty strong language out of our legislature.
Having dealt with a few estates myself and having to liquidate some estates, it seems like to me it would be so much simpler with a lot of people. Now, a lot of them they got it fixed up and everybody knows what's going on. But I've seen lots of them where, okay, surprise, surprise, there's somebody else out there that's going to challenge what's happening, and it's a big squabble. And a lot of a lot of the value of an estate is lost to would be to the heirs if they didn't have the fight.
Well, let's talk about challenges because it seems like a good topic.
It is.
Here's a rule of law. You can disinherit a child, but you cannot disinherit a spouse. Okay.
Yeah.
Spouse enjoys what they call elective share, which you can exercise. It's an old common law form of action.
Right.
And basically, you could write in your will or write in your trust that low down, cheating, no good spouse of mine gets zip, squat, zero, nada. She's going to get anything. She can't have anything. Well, she can exercise elective share and get up to 40% based on how long the marriage was, on and on.
Yeah.
And now, so I'm not going to talk about the spouse, but if you can disinherit a child, you can just say, now, when you disinherit somebody, like a child or anybody else for that matter, any other family member, there's a right way to do it and a wrong way to do it. The wrong way to do it is just say nothing, because, especially if it's a child, because if there's a presumption in the law that a person leaves their bounty to their natural descendants, right? So your bloodline kids, that's where you would leave it.
Yeah.
And that comes out of Scripture, right?
Yeah, yeah.
And so there's a presumption of the law. The presumption is like, if there's nothing else, the presumption carries the day, but a presumption can be rebutted, right?
Yeah.
But, in other words, so if nothing else is done, the scales are tipped in the side of the presumption. But, but you can disinherit a child, but the right way to do it is to say it in the document. And what we say, I would say, okay, I'm going to say, and the language you need to say because if you're silent, okay, if you're silent, somebody can come into court and challenge it and say, well, mom and dad didn't say anything about me.
Yeah.
They didn't say I got anything, they didn't say I did anything, it was silent about me. So therefore, they must have forgot me, because there's a presumption that you leave it with your natural descendants, right?
Yeah.
And so that's an argument, that's an argument. So, now how do you figure out whether they forgot them or not? I mean, they're not here to defend their position.
Right.
And now you start to think, well, if they really wanted you to get something, maybe they would have wrote it in. But if they didn't want you to get in something, maybe they would have wrote that in.
Yeah.
Or given a reason or something like that. So
Right.
it's an argument. You can challenge that. So what we do is, if you're going to disinherit Joey, you can say it is by no accident or mistake that we are not providing for Joey after death. Now, they can't come in and say, hey, they must have forgot about me because, hey, it was expressed in the will. You don't get anything. You know what I mean?
Right.
So you can't. That argument is we've defeated that argument.
Right.
Now you have to argue why you didn't get anything. What's a tougher? That's a awful big burden to carry in a court of law. What would you say? Why should you get more? I don't know, because you were nicer to them, or you went to the grocery store for them all the time. You're not going to get too far with that argument. So the right way to disinherit people is just say it. Now, when I tell people that, they say, "Well, I don't want to make them mad." I said, "Well,
It's going to.
It's going to. Now, another thing, when we talk about challenging stuff, suppose a lot of people say, "I got to be equal. I got 5 kids. I got to give them each 20%."
Yeah.
This one doesn't need it. They married into somebody super rich, and they don't need it. And this one is completely destitute, and on and on. But I got to be equal. There is no requirement whatsoever that you are equal. Okay.
No.
It's your stuff. You do what you want. Okay. Now it equals what you think it is, the writer of the trust or the will. It's what the trustor thinks it is. So suppose, and I've seen this happen. Suppose you have a couple of kids, and one marries into a very wealthy family, and money is just not an issue.
Yeah.
But for the other one, maybe they're a little check to check, struggling a little more, right?
Yeah.
I've seen people leave a lion's share to that person. Now they're not intending to, what's the word I'm looking for? Shun the other one.
Yeah.
They're providing where they think it's best put. And I agree with that logic. I agree with 100%. Now you could say something in there if you want. Say because someone's pretty well off and
Sure.
one's not, I'd choose to leave 80% to this one, 20 to the other.
Yeah.
Just however it works out. But that is exactly what some people do, and I think that's good logic. Now, if a third party reading that will, it looks terribly favoring one over the other. But there's a reason for it. And so it's equal in the maker's mind.
Right.
My job is to provide for the kids, well, not provide for them, but my job is to pass it on to the kids. And to me, this is an equitable way because one needs it. The other one doesn't. Now, I've also seen situations that appear to be unequal, and that is, it's what we call an offset. We've had people that say, okay, my son, I got 3 children. My son, about 5 years ago, wanted to buy a house. Him and his wife wanted to buy a house, and they couldn't swing the down payment. So I gave them $50,000 to make the down payment on their house. They bought it, but I'm not going to consider it a loan. I'm going to consider it an early inheritance.
Yeah.
And or if it was a loan, they'll say, so at his death, let's just say they're considering an early inheritance.
Yeah.
They'll say but I don't want that to be favoring him over the other 2 children if I got 3 kids, because if they all get a third at my death, now he's going to have been favored because of the actions during life, right? Right. So it's called an offset. We can say, okay, here's what we're going to do. We're going to divide the property by 2 to the other 2. Divide every dollar by 2 until each of them gets $50,000. So now we're kind of at the equal point, right?
Right.
You guys are getting $50,000 now after death, and the other one got $50,000 5 years ago during life. Now we're going to start dividing every dollar by 3 after that. So it's called an offset. And we do that quite often. Or if it wasn't a gift, like early inheritance, and you have a note and they're supposed to pay you back, sometimes we'll put language in there that says, we'll do the offset based on whatever the indebtedness, if there is any, at our death. So in other words, if you're paying it off and you're $25,000 paid off and $25,000 to go when they pass away, now the offset is going to be for the balance due.
Yeah.
And it's a way to be equal. Now, to a third party looking at the trust or the will, it looks like it's lopsided, but it's not. Equals what you think it is, and equals what we'll put in it. You don't even have to put a reason. As a matter of fact, I heavily advise people not to put the reason in there. Like, let's take the guy who said,
Yeah.
didn't call or didn't send him a Christmas card in the last 10 years.
Right.
If you put that in there, see, I know people just have this overwhelming urge to say why.
Yes.
This is not a good time to do it. Here's why. Suppose we put in that trust. Now, this guy was saying that, but suppose the person writing the trust feels estranged from their child, and they say, you know, they haven't called me in 10 years, and they haven't even sent me a Christmas card. They chose their in-laws over me, so I'm not going to leave them anything, okay? And if you put that, let's say you put that language in the will, or the trust.
Yeah.
Suppose the person now can turn around and say, hey, I'm going to show you the phone records for the last 5 years, and I called them 2 or 3 times. Or suppose they can prove that they sent them a Christmas card in the last 10 years. Now, I think a legal question arises. Does the disqualifying reason you put in the instrument, is that now not, if it's no longer true, does it change the disinheritance?
So you're
If you say, you never called me in 10 years, and after death they pull up phone record and say, yeah, I did. I called him a couple of times in 10 years.
Yeah.
Is the disqualifying language that says, I'm leaving you out because you haven't called me in 10 years. Now what do we do about the disinheritance? It seems to have been defeated.
Wow.
I don't know. I wouldn't want to argue that in court.
Yeah.
So you don't put a reason. It's not necessary, and it can come back and bite you.
Yeah.
Because, you know, it's general. Like, well, they never talked to me. Well, you know, you talk to them.
Yeah.
Or, you know, they chose that family over me. Well, what does that really mean? I mean,
Yeah.
so if you want
Well,
to
you don't have to put a reason at all.
Nope.
You just do what you
Just put the effect.
You just put your intents in there, and that's it.
Well, I mean, you don't, when you leave, if you've got 3 kids, you leave them each a third, you don't put a reason why you're doing that, just other than that they're my kids.
Yeah.
But if you're going to disinherit one or give them less, people feel the need to say why.
Yeah.
Yeah, feel the need to say why, say it during life. I mean, don't put it in the instrument. Because
Right.
the instrument is exactly what your intentions are.
Right. Interesting.
Yeah.
Yeah. I guess that's lawyer speak, though.
Well, I've seen that. I've seen, you know, I read court cases when they come out, other states too, because we don't get a lot of stuff come out of Tennessee, but it comes out in a lot of other states, and you know, I've actually seen that one. That's why, you know, when you see what courts do when that happens, now you know what to do and what not to do. I like to do, when I read court cases, it's called precedent. I like to do what the court says works and not do what the court says doesn't work.
Yes. And that's what you're hired to do.
That's exactly right. I mean, that's a winning combination if you do that. I can think of a time when there was you know, when we do our asset protection trust, you know, we talk about, we limit the access to principal when we do that. And if you hadn't heard me talk about this, maybe this is hard to understand, but you know, what gives us the creditor protection against any creditor, but especially long-term care, is this access to principal. We don't have it. It doesn't mean we can't get at it, doesn't mean we can't control it, but we can't have access. And access is, you know, property coming directly out of the trust to the maker of the trust.
Right.
And so, and it's called the any circumstances test, according to our courts. The any circumstances test means if there's any circumstances at all, any, big, little, small, any, that the maker of the trust has access to the principal, then they have access to all the principal.
Yeah.
And so we don't ever want that to happen. So I have very strong language in my trust. And years ago, so there was a case where the court, somebody challenged that very concept. And in the trust it said, okay, the trustor of the trust is the trustee.
Right.
And that's okay, you can be the trustee, right? But in the trust it said the trustee is entitled to a reasonable compensation, which you probably find in every trust. The argument the state made is if he's going to be, if the trustor is the trustee and the trustee can be compensated, we're assuming they're compensated out of principal, and that's circumstances where that trustor can get. Now, I looked at that, and that case failed on that argument. But I went in, when I do my trust now, every single one of them says the trustee is entitled to compensation. However, if the trustee is the trustor, no compensation from principal or income.
Oh, okay.
Just to defeat that from ever even coming up.
Sure.
Now that court case, it didn't get the high courts, but it was. I thought, you know, I wasn't sure I thought of that. And,
wow.
And now I put, so I know. It's like, okay, I can see where that's a circumstance, or could be a circumstance. Why don't I put some language in here to make sure that it never is? It absolutely never is if you do that. So you know, it's been doing that for some years, you know.
Interesting.
5, 6, 7 years. But you know, that's where this business of reading court cases. You know, you do what the winners do and don't do what the losers do, and that's a winning combination. Whether you like it or not, it doesn't matter. If you know what the court's going to rule, because you know a court they don't make it up as they go. If you ever read a court case and they say something, below it'll be like a paragraph of all these other cases where they said the same thing. They don't,
Yeah.
no, they don't answer anything new. I mean, they will answer something new, but practically a lot of things have already been answered. So when you take
Sure.
something to court, they're basically say, here's what we said in this case, here's what we said in this case, here's what we said in this case, here's what we said in this case. So we're saying the same thing as we've always said on this issue. Same thing. So if you know what they've said, even if whether you like it or not, you know that if you put it in, that's how they're gonna rule, if you do that.
Yeah,
And
absolutely.
if they say the opposite and say, hey, we're not gonna uphold this because in this case we said we're not gonna uphold it, in this case we said we're not gonna uphold it, in this case so we're gonna continue to not uphold it because it's not proper, for whatever reason. It's unconstitutional, it's ambiguous, or whatever the reason they're shooting it down, but.
That's that thing called precedent.
Yeah, it is precedence, you know. It's,
Yeah.
I think the Latin term is stare decisis, which means once settled, always settled. And every now and then, something will come up that the court will answer, which is, they call it a new question of law. And it's, in other words, you're saying, this question's never been asked before, so we need an answer to it.
Makes you wonder how often that
It
happens.
does happen. You think, well, it seems like we've asked every question there is to ask, right?
It does.
Oh, no, you can't make this stuff up. It comes up, and you know that's exactly what the Supreme Court does. Both our
Yeah.
state and our, well, the federal Supreme Court has certain constitutional jurisdiction, but our state Supreme Court, that's exactly what they do. When you file what they call a writ of certiorari, which is asking them to hear it, because in Tennessee the appellate courts have to hear. It's the first level of appeal is a direct right.
Yeah.
But when you go to if you don't get the answer you want from the appellate court and you go to the Supreme Court, that's appeal by permission. They decide whether they're going to hear it or not.
Yeah.
And if you send it to them and they'll send you like a 3-sentence letter or 2-sentence letter that just says we deny certiorari, we're not going to hear it. I pretty much is telling you we've already answered that question.
Yeah.
That's the way I interpret it.
Yeah.
And so, but
question's
if they say this is a question of law that's not been answered yet, so we're gonna grant certiorari to give our courts throughout the state a uniform answer of how we deal with this.
So does that mean that most cases that actually make it all the way to the Supreme Court are questions that haven't been thoroughly vetted? I
Well,
guess?
there's that, and there's also ambiguity. Let's say you're researching the law, and I don't know, the courts out of Jackson have come up with one answer, and the courts out of Knoxville have come out with something different.
Yeah.
So the Supreme Court will then take a case like that up to create uniformity.
Yeah. Okay.
It can't be one way one place and one way the other. I mean, maybe circumstances could do that, but I doubt it. And there's a whole bunch of other reasons. There's several other reasons why they'll take the case, but that's a big one. When I used to practice criminal defense work, you know, I can tell you how many times I appealed to the Supreme Court, and they turned about every one of them down because criminal law has really been thrashed out.
Sure.
But I mean, you can come up with a unique question of law that needs to be answered.
Yeah.
I had one once, but it never, I never got granted a case in front of the Supreme Court. But I had one, and here's the way it works. Usually when you send your writ up there and ask them, you hear it back in about, I'm going to say 60 days or so. You get this letter, it's got about 3 sentences, we looked at it, thanks for asking, but we're not going to hear it.
Yeah.
Kind of like that. And it's very short, and usually comes around in 2 months. And I had one that was up there for something like 9 or 10 months.
Okay.
And I kept saying, they gotta be thinking about it. They just gotta be thinking about it. It was a very involved issue, very technical.
Yeah.
And I said, man, they gotta be thinking about it. And that's exactly what they were doing because they have to have, I don't even know how it works. I think they have to have at least 2 or 3 of the justices agree that it needs to be heard.
Yeah.
And somebody was probably championing that and trying to talk others into, we need to hear it. But then after about 10 months, I get the letter saying, we're not gonna hear it. And it's like, well, they had to be talking about it.
Tossed it
decided
around
whether-
anyway.
Yeah, so it was close to one they wanted to hear.
Yeah. Yeah.
But I always thought it would be exciting to go there, but I think it would be pretty spooky too.
I would say.
I've argued a blue million cases in front of the Court of Criminal Appeals, and the 3-judge panel, and you get used to that. But the first couple times up there, it's very intimidating.
I bet.
Because you'll be talking to them and they will constantly interrupt you, or they can do that. Sometimes they do. Sometimes they do. Sometimes they don't.
Yeah.
If they interrupt you a lot, I interpret that mostly that's a sign that they're not too crazy about your argument. But it doesn't mean that all the time.
Yeah. This is off topic maybe just a little bit, but and maybe I should know this. But what is the progression to get something all the way to the Supreme Court? Is it differ from different case
It's
to case?
it's kind of the same, but it depends on where it originates. But let's say it originates in General Sessions Court.
Yeah.
You know, you think you've been done wrong, and you appeal it to our Chancery Court. And
Yeah.
that would be the Circuit Court or Chancery Court, depending on whether it was civil or criminal.
Yeah.
They follow kind of the same path, just different courts.
Okay.
Now, your Chancery Court wears two hats. They can be circuit, or they can be civil. You know,
Okay.
or criminal or civil. Civil is what I'm saying.
Yeah.
So let's just say it's a criminal case. I've not had to appeal anything civil because I never did much civil law, and
Sure.
I've never had to appeal anything in what I'm doing now, which would be civil. But I did a lot when I did criminal defense work. So you get to General Sessions, you don't get like the answer you get. You can take it to criminal court, which is our Chancery Court, and then you can take it there. If you don't like the answer you get there, you can go to the Court of Appeals. And now those are in different districts. We got 3 districts in Tennessee.
Yeah.
So here you go to the criminal court in Nashville. Okay.
Yeah.
And that's a 3-judge panel, and they'll hear it. And if they give you the answer you don't want, then you can appeal by writ of certiorari to the Supreme Court. And now, up till now, everything was an appeal by right, meaning I don't care how stupid your argument is or how many times the court has already said that.
Right.
You know, let's say this. Let's say you get pulled over and they search your car. And you say, by golly, that's a Fourth Amendment right. You can't search my car, which was
Yeah.
been decided a long time ago that they can pretty much do whatever they want when you're on the road.
Right.
And it's a stupid argument. Or let me put it this way: it's an argument that's specious, frivolous, without foundation or merit.
Yeah.
Okay, and
Yeah.
but you make it anyway. All the way up to the Court of Criminal Appeals is an appeal by right, so they have to hear it. Now they won't hear it for long when you do that, but they'll hear it. And but then you can, after that, if you don't like your answer, you appeal it to the Supreme Court of Tennessee, and they, said they decide whether they see it or not. But if they turn you down, now I'm trying to remember because I think I only did this once. Now you have to go to the federal district court. I'm pretty sure.
Okay.
They got how many of those they have? Like 9.
Is there 9? Yes.
9,
I think there's 9.
Ours is, gosh, I'm ashamed of myself. Ours is the 6th. I can't remember. But anyway, that's the Court of Appeals for the district court. Okay. Actually, I think you have to go to the district court first, and then the the appellate district court.
Okay.
I'm out of my lane on that because if the Supreme Court of Tennessee is not going to hear it, I don't usually pursue it unless I'm absolutely sure it's that kind of an issue.
Sure.
Usually when I take a case, it's like, hey, this has merit, but it's not a slam dunk, it's that kind of thing. So,
Right.
And then I think it goes to the district court, then it goes to the District Court of Appeals, and then can go to the United States Supreme Court.
Interesting. And the Ninth Circuit Court is what I always hear about.
That's California.
That's California. You always hear that they've taken it to the Ninth.
I'm going to say something, and I'm going to say it because I was told this in law school. I swear to gosh, I was told this in law school. I think it was in criminal law, or maybe torts. But anyway, the instructor was very knowledgeable. One of the instructors, for the criminal constitutional law that I had,
Yeah.
was a member of our Supreme Court.
Oh, really?
And at the time, he was the Chief Justice. So, I mean, how cool is that to have an instructor in law school that's Chief Justice of the Tennessee Supreme Court?
Yeah.
His name was Adolfo Birch, and he has passed away since. But he said, we were talking about something, and constitutional, and the Ninth Circuit Court of Appeals came out with a decision, and of course it went to the Supreme Court and they overruled it. He made the comment. Now somebody asked about that, and he said, you know what? If you see it comes out of the Ninth Circuit, just disregard it. We don't pay attention to what the Ninth Circuit does because they're so out in left field. They're always overruled. So that's exactly what they told me.
How about that?
So, you'd think if you got a jurisdiction so rogue that we'd do something about it, but I don't know.
That does seem right. Because that's what you hear about in the news all the time.
Yeah.
The Ninth.
Ninth Circuit, they are very. I mean, it's not just California. It's I don't know where the lines are drawn. I think it also includes, Oregon, Washington, and some. I mean, there's a line drawn over there, but California's in it, and I think the bulk of things come from there because that's where all the population is.
The left coast, as we call it.
Yeah. But anyway, we didn't talk too much about estate planning. The good news is estate planning arguments and challenges never really that I have seen never get very far than the court they bring it up.
That was interesting though, but it boils back down to with estates and estate planning that with proper planning you have control.
Yeah.
And if you get good advice on how to do it, which your services provide, then you have complete and utter control, and you don't have to worry about it.
And we don't see many of them get challenged. Or if they get challenged, they don't get anywhere.
Yeah.
Because I like to tell people, if people say, well, can my kids challenge this if I write this trust? And the answer is, well, I can't control what your kid's going to do.
Yeah.
They can challenge it, but I can do the next best thing and make it like next to impossible for them to be successful.
Yeah, that's like, I've had people ask me, well, can I get sued over this, that, and the other, And I said, well, honestly, anybody can sue you for anything. Doesn't mean they're going to win.
Well, some of the things
you
I've
can be
seen,
sued any time of the day or night.
one of the things I've seen is when things get challenged, it's usually like it's not clear how to divide the property.
Yeah.
That kind of thing. It's
Yeah.
not so much they're challenging the trust or the fact that it's a valid trust or something.
Right.
It's usually because some people will say, I have this farm and I'm going to leave each of you a third of it. Well, there's no lines drawn when you do that. So it's called an undivided 1/3 interest. Okay. And there's no lines drawn. And so now the three heirs are like, okay, one says, I want to sell mine. The other two say, well, I want to use it.
Yeah.
What part can I use? What part can I use?
Yeah.
And the theory is, well, if you have an undivided 1/3 interest, then you can use it all. You only own half of it. If you sell it, you only get a third of the money. But if you have two people that want to use it, and they can both, it's called equal right of possession, equal right of entry.
Yeah.
They can both, either one can use it for whatever they want, all of it. But if you got two people using it and they have a inconsistent use, say one wants to farm and the other wants to build an amusement park. Okay?
Yeah.
I mean, they're inconsistent. You can't do both, right?
Can't do both.
That's when we start getting into court because
Yeah.
who gets what can they do, and it's kind of comes under what they call petition for partition, and that's how we're going to divide this property.
Well, see, that's when I would advise them to auction a thing, and the best man wins.
Well, usually the end result of a partition action is to court forces the
order to
be
sell.
sold, and if you really want it, then be there to bid on it.
Yeah,
that's a possibility.
Seen that happen a few times.
But those things usually settle because they take a long time. They are very expensive.
Yeah.
Don't recommend you go through a partition action. They are just. In the court, we've changed our partition law where the court is supposed to really bend over backwards to try to divide the property in kind, meaning actually draw these lines. But it's hard because when you got a piece of property and you're drawing lines, you got road frontage, right? You got water rights, and maybe you got a nice house built somewhere. So if you draw this line in half, the one that gets the half that's got the house on it, it's obviously lopsided, right? Because you got more improvement value on one than you have on the other.
Sure.
And so it's difficult. I mean, they do it sometimes, but it's a tough call. What's equal? Because they're entitled to. Let's just make it simple. Make two people. They all have a one half undivided. Where's the line that makes that equal? Value wise.
Yeah.
Well, how much value to put on? What if somebody has 200 feet of road frontage, and the other one only has 100 feet of road frontage?
Yeah.
And say, well, the purpose for road frontage is so you can put a driveway out there.
Yeah.
I mean, is it equal that one has, maybe you physically can't draw that line to make an equal footage. Or to give one access, we gotta have a big old long easement over the one property to get to the half in the back where you would have something. It gets very complicated.
Run into that stuff sometimes.
And I don't like being involved in them, so it's just, there's no good answer. Nobody's ever happy at the end of partition. I'm telling you, there's no winners, there's all losers and no winners in that case. So, but, if it's a controversy, that's what the courts are for, and that's what they'll try. That's what they'll try to do.
Absolutely.
Anyway.
Yeah, we're winding down to the last few minutes, and by the way, headed into Thanksgiving week. Next week we will do an encore presentation,
which means you'll play a recorded one.
Yeah, we'll play a recorded version next week of our visits here, and that's good and okay. We want everybody to enjoy their time off and their family and all that. Talked about.
So if you listen to us regular and you miss next Friday, you probably heard it already.
Yeah, that's quite all right.
But maybe you'll get lucky and it'll be one you want to hear again.
Yeah, absolutely.
Just don't do this one again.
Just don't do this one again. Yeah.
I said pick one from a year ago.
Yeah, we'll do that. I'll ask Miss Charlotte to dig one up.
Yeah, because I know they record them.
Yeah.
So I don't know if they played the Facebook part again or not. I'm not sure how that works, but the visual radio.
I'm not
part.
sure. I think they do. I don't really know.
It is still visual radio.
Yeah, it is.
I used to be able to see myself on one of your screens, but I don't.
Well, it depends on how I've got it set up.
That's all right. I don't need to.
But
I know
anyway,
it's
it's there.
there.
I kind of monitor it here on my phone. So
I know not to do things like scratch my nose or stick my finger in my ear or something while I'm on here because it is broadcasting of the visual thing.
I look at the to make sure we're on, and I keep looking at how my ball spot shines in this.
There you go.
in this thing. So there it is.
If I could, I think the visual radio is a neat concept.
Yeah.
If I was a caller and I called in, I'd want to watch it to see what kind of reaction I get when I ask the question.
Yeah. I didn't know, we talked about this a little bit over the air. You've got some development on the square. Do you want to talk about that a little bit, or do you?
Next time we're on.
Next time
Things
we're
are finalizing as we speak.
Okay, all right,
As a matter
very
of fact, today is part of that.
Well,
Yep.
you might want to update just for fun of it, the Star Theater. You got anything going on
Oh,
there?
yeah, that's right. My wife Miss Tammy would like me to say that.
Yes.
The Nutcracker.
Oh,
Okay?
yes.
She says, don't go to Nashville to watch it. You can watch it right here in Pulaski, and it is good, every bit as good, if not better. And it is the first 2 weekends in December. So what that means is I don't see a calendar, but first 2 weekends.
Okay.
It's Friday, Saturday, and Sunday. It's Friday at 7 p.m., Saturday at 7 p.m., and Sunday at 2 p.m. But don't write the Sunday at 2 p.m. down because both matinees are sold out.
They're already sold out.
But it's the first Friday and Saturday, and the second Friday and Saturday in December at 7 o'clock. And there's still tickets available, but you know, the Nutcracker, you know, you got a lot of kids in there. I think there's 60 something. And those 60 kids have family. They have brothers, sisters,
yeah.
moms and dads, grandma and grandpa. And so you know, a lot of folks come to see folks in the Nutcracker.
Sure.
So don't wait to get your ticket. If you wait, I have some people say, I'll just get a ticket at the door.
You won't have the
if you
problem.
show up for a matinee, I don't know what they're going to do with you. Because we don't have a seat, we can't go putting people not in seats, right?
That's
Fire
December
codes.
12th and 13th and 19th and
It
20th.
can't be the 12th. It has to be because 7
Oh,
days
I'm
before
sorry.
that.
I'm sorry. It's 5th and 6th and 12th and 13th.
5, 6, 12,
5, 6,
13.
and 12 and 13.
Those are the Friday, Saturday, and Friday,
yeah,
Saturday.
I missed it. Yeah, the first
But
two Fridays and Saturdays.
I don't remember the price, but you can go to startheater.org. And now Star Theater is 2 A's, STAAR. It stands for Southern Tennessee Area Arts Repertoire.
Yeah.
So it's Star with 2 A's, theater.com.
That'll
I
work.
can't remember if it's TRE or TER, because technically the word is TRE, but nobody ever does that. So, but
Don't ask me.
if it doesn't come up, do it the other way. Theater, TER, or TRE.
You can probably just Google the theater on the square.
It'll come up. It'll come up. Star Theater.
Theater Pulaski or
That's
whatever.
right. It sure will. So,
You can Google it and find it pretty easy.
anyway, we want to talk about the seminar coming up tomorrow.
Yes,
Which is
that's
the 22nd.
tomorrow.
It's going to be at the Williamson County Public Library in Franklin. The physical address is 1314 Columbia Avenue in Franklin. If you want to let your GPS guide you there, it will. We have it at 10 o'clock. Be there a little bit early because I try to start just as close to 10 as I possibly can. A lot of times, like here, if I see several people in the parking lot trying to park, we'll punt it a couple minutes, but not much.
Yeah.
And it's a pretty good presentation. We got a pretty good crowd. I've still not been to that venue, so I'll be seeing it for the first time tomorrow.
It's wonderful. You're going to like it.
Yeah, the girls have planned everything. And I mentioned earlier that I can't tell you when the next one is. I know it's in the second half of January, but the girls over the holidays will plan the entire 2026 schedule of seminars, so I'll have that come pretty soon.
Absolutely.
So, we're going to jump over all the holidays. We do it every other month. It'll be at the end of January.
Yep.
So, anyway, if you want to talk to me about anything or call about the seminar, call me at Pierchoski Estate Law, Pierchoski Elder Law. The number is 931-363-7222. 363-7222. Or go to my website at estateplanstand.com. There's stuff to read on there if you want. You can look at the calendar, see where we're going to be. If you want to ask your question, you can get the phone number, or you can send your question by email.
Absolutely.
And we do this show every Friday from 8 to 9.
Yep.
Call in and ask your questions, or share an experience, or just whatever. It's, just make the questions remotely about estate planning.
As much as possible, yeah.
Don't call and ask me my favorite color or something. But if you want to, go ahead. It's blue.
It's blue. It's blue.
It's hard for me because I'm a little colorblind, so blues and grays and greens are kind of difficult for me.
I have a little bit of that.
Yeah.
I really do. There's a certain shades of a taupe and brown green that I think is brown and it's green or green and it's brown.
I've been known to hold up a pair of socks and say, "Will these go with these pants?" to my wife. She knows why.
I solved that problem by kind of getting a lot of the same things, so I do that. So.
I used to be a pilot, and it was never enough for me to not be a pilot, to be colorblind. Because when you're a pilot, there's certain things, there's certain lights as you're coming.
yeah.
You come in on landing, there's what's called VASI, visual slope indicator.
Yeah.
It's white or red.
Yeah.
You have to be able to tell it.
Stan Pierchoski, everybody, check him out online at estateplanstand.com. That phone number at his office is 363-7222. Good to have you, brother. See you next
Always
time.
a pleasure.
See you next time.
Happy Thanksgiving.
Yes, sir.
This is WDXE W287.
That thing's a whole minute off.
237 FD.
And an hour.